after 3 weeks on the prayer of petition. Yes.
I will mention item number 10 and 11.
When?
After what?
After 10 days.
Maybe.
Yes.
To consider other segment, attachment item number 1.
When?
Next week.
2 weeks.
Yeah.
On the prayer of petition. Yes.
No, I'm for the
Respondent.
Seven.
Yes.
It may be taken Friday.
After 10 days for the petitioner. Petitioner? 7 and 8.
Maybe a big date.
You have missed the chance. Yes. Next.
with the consent of the other side method, I recommend item number 13.
13.
Yes.
Why this is matter is listed? Orders why?
Orders
Item number?
13.
Rejoinder affidavit. The petitioner seeks for further 2 weeks time to file the rejoinder affidavit. Prayer is allowed, list accordingly. Item 13.
Rejoinder, my lord, we have filed
Already filed. Then why you need an exam? Okay. Petitioner wants praise for exam. On the prayer of the learned counsel for the petitioner, matters that John he to line list after 2 weeks. Yes.
I beg to mention item number 15. The
Item number?
15.
15. Yes.
The matter has become effective.
Learned counsel for the petitioner.
Yes.
Petitioner. MS, your name?
Reader,
Your name is not there.
Yes.
Miss
I'm on behalf of IRFP.
M. Das. You are M. Das.
Reader,
B. Das. Learned counsel appearing on behalf of
IRFP.
Mr. I. Ropik, learned counsel for the petitioner, submits that the order has already been complied with. First up, Mr. M. Bhagavati, learned counsel is present, representing respondents. First up, accordingly, that's contempt petition stands closed. Yes. Yes, Mr. Roy.
Yes, now, my lord. We will pay proportionately, my lord.
Instruction, it triggers a payment of balance amount of 10 lakhs 20.
My lord.
That we have received
Yes.
on last occasion.
On last occasion, in some other matter. So, when we receive the amount, we will pay proportionately. And we
Okay,
are the 31st of March, we will get it.
Okay, Mr. J. Roy, non-appears for the petitioner on call. Mr. J. Roy, learned counsel for the petitioner.
Respondent.
Sorry, respondent.
Yes,
Has respondent, learned senior counsel for the respondent submits that the Accountant General A&E Assam has already sanctioned an amount of rupees
50 crore.
50 crores for payments of arrear salaries slash pension dues, pensionary dues, which includes the claim of the petitioner also. First up, it is further submitted that as the many other persons are to be paid against pensionary benefits, etc. Many other employees are also to be paid out of the aforesaid amount. First up, the corporation has decided to make payment on the basis of on proportionate basis. First up, he further contends that the proportionate payment would be made by 31st of March.
We are expecting by 31st of March.
By 31st of March, subject to actual release of the funds. Full stop. In view of such submission, matter stands adjourned and be listed after 3 weeks. Not 3 weeks, 31st of March.
But
So list in the month of April. First week of April.
Lordship, that I'm ready with the case. So I've gone to the office code. We have made private response.
Hmm.
If the service as regards the state. But also they did when
Who are they?
the selected person,
Huh?
selected candidate,
What is this post?
trade helper.
Mr. Doctor, none of us looked into this aspect
My Lord,
on last occasion.
one thing your lordship kindly see, they are beneficiaries
Mm.
and most of them have been.
Who
already
is the
appointed.
employer? Now they have joined.
We
Yes.
have preferred a custom application.
Huh?
We have preferred a custom application which is pending.
Okay, that is fine. Now, you are an employer.
I am, my Lord, appearing on behalf of Tata Memorial Hospital and Dr. B. Purva Cancer.
Where are these persons appointed as on date?
Here, B.
Yeah.
Purva Cancer.
Can you serve a notice upon them? If she will take the steps, you serve a notice, we'll decide next week.
That can be done, my Lord. Only out of these 3 persons could not be appointed.
Ah.
Because in the meantime, the stay order granted by this honorable court
Hmm.
was given to us. So
Hmm.
seeing that, my Lord.
To understand, they file a contempt, but according to you, we are not aware of this order. So we appointed some person,
Yes.
some are still to be, 3 persons are to be appointed. We are suffering, so you have filed a stay vacating order also. And these persons are not being, some addressee 7 days absent and addressee unavailable. So I think you have suffered. Let us take a chance. Madam will ultimately it's a question of selection.
Yes.
This is my view. What subject to
And
what
on
you
the
say.
merit, my lord, your lordship will find both the petitioners failed. Now, whether this petition is maintainable at all,
That's good.
No, that another aspect of the. Have
My-
you filed any interim modification order of
my lord,
vacation?
yes.
We have also prepared an application for extension. of the
Okay,
extension.
we presume that is extension. Let us just understand what is your
That's the
merit of
matter. Yes,
the
my
case.
lord,
If we
lordship.
think that prima facie you are having a merit,
Yes.
then
So your lordship will take into account one more thing,
Uh.
because they are saying like we have participated.
No,
in
no,
the
we'll see.
selection.
We'll see. Therefore,
Fine.
just let us have a prima facie view.
Fine.
Then we'll decide whether we'll proceed further
Yes.
or we will go for the stay vacate. Let us understand, because we know going to the stay vacating will amount to determining the entire issue. Because we'll have a satisfaction.
Entire matter we take it up because the matter.
No, no,
was-
entire matter we cannot taken up. Suppose we decide that your writ petition is liable to be dismissed, then yes, of course, will they are not being an aggrieved party. But suppose we think that you have a case, of course, we'll have to call them.
Another thing your lordship will take into account, lordship, since they are the beneficiaries, but they have not like, they had no audacity to come before the honorable court after receiving notice.
No,
Why
that's
not?
that-
They are
that-
protecting the.
no, no,
employee and
no. That
protecting them, my
issue is like this. They have not come. That will not give a conclusion that there is a defect in the selection. At the same time, suppose there is a defect in the selection or the selection is liable to be set aside. Moment we do that, this office note will lengthen this process. They will come and file a review where no notice has been served. They will go to the division bench. Everything will be lengthened, and in that process, if writ petition is allowed, you will suffer. If not allowed, nobody will suffer. You will suffer. Okay, so therefore, let us just have the an understanding. We have time today. That's why others will have to go home. Isn't it? That's why we have fixed it today.
Yes.
Okay, let us understand what is the selection. Yes, Mr. Doctor, take a seat.
Lordship, there are two petitioners. One more, may I submit one more thing? Another petition is also pending before.
Okay. Okay, now let us understand where is the advertisement.
Advertisement, your lordship will find it page 20, my lord,
Page 20.
20. Annex 5, my lord. The Tata Memorial Center is a comprehensive cancer center with a mission to achieve the highest standards of the patient care, cancer prevention, cancer research, and professional development.
What are the posts?
There are various
So
numbers
far
of posts.
relating to this
Trade
case?
helper,
Huh?
Page 22.
Page?
22, madam. Today number 15.
Serial number.
Yes.
Trade helper.
Yes, lordship. Unreserved 10 posts, for OBC 4 posts, for ST 3 posts,
Where do you get serial number 15?
15, madam.
Level, this is okay. Unreserved 10, OBC, SC, ST, HS, we do not know. What
But
is,
here it
okay, anyway. So,
Yes, but
which category do you belong?
is general.
General.
Lost.
So, you are under 10 post of unreserved.
Yes,
Okay.
lordship.
What are the qualifications?
Qualification is 10 plus 2 plus 1 year experience.
Where do you get that?
ICU. Lordship.
Qualification. Okay.
Yes.
10 plus 2 standard with 1 year experience is OT, ICU, diagnostic, lab.
Lordship.
And what is the procedure to be followed
Uh,
in the selection process?
lordship.
Any examination? Any or oral interview only?
Written test,
Lordship, page 26.
then interview.
It's written in their this one, admit card,
Page
my
26.
lord. This is ref, as a lordship.
Yes, yes.
This has reference to application for the post of trade helper. The selection for a trade helper will comprise written examination followed by skill test of successful candidates on Friday, 28th August at 9:30 a.m. At academic hub so and so. You are requested to bring your so and so for written skill test. All the original certificates of so and so. And copying and canvassing.
Okay, written examination and skill test.
Yes.
Then
Then your lordship will find the syllabus, this, my lord, down below, page 26. Syllabus.
20, page 26.
Yes, my lord,
No traveling, please note.
down below. Syllabus, GK,
I'm
General
I'm not getting
last
A,
line.
B, C, D, E, F, G,
I,
Z,
E,
H,
IJ, syllabus.
I, J, syllabus.
GK, General
English, maths, knowledge about
the
equipments in OT,
yes,
ICU and labs.
I know.
Okay.
lordship. Then these are the call letters wherein both the petitioners have got the call letters, my lord.
There are two petitioners.
There are two petitions. Then they have participated, my lord.
Mm.
Then your lordship will find anomalies in the process of selection at para 9 of the report.
Paragraph 9.
9.
The statement.
Yes.
Okay.
That the anomalies and malpractices which are held in the examination hall are as follows. My lord, non-uses of OMR answer sheets. No OMR answer sheets were given for answering the objective questions. Instead, on the Xerox question papers were given to the petitioners as well as to the other candidates where they were supposed to put tick marks for the correct answer. Thus, it is evident that the invigilated themselves have answered the unanswered questions of the preferred.
No, I'm not getting. It is where.
Para 9.
No, that we are getting it. Was it mandated to be an one OMR sheet based in the
Yes.
advertisement? Then,
Then thereafter, my
so this is gone.
let us see once again if I find it.
Okay, then next.
Yes. Previous instruction question booklet. Petitioners were quite astounded with one of the written instructions in the question booklet that any candidate can change their answer and the same can be ratified with invigilator countersign. Taking it as a lenient candidate did it frequently and subsequently they got ratified with invigilator. That was admitted by them.
Okay.
Then question away from syllabus. The stipulated syllabus was not followed in the written examination.
Okay, that is not a ground.
Oh, my lord, because syllabus is GK, English.
Hmm.
That is not done. Syllabus is specifically mentioned
Hmm.
that there will be GK, English, and other subjects, my lord. The stipulated syllabus was not followed in the written examination. Questions from English and GK were not perceived in the same way. As per the syllabus for knowledge about equipment in OT, ICU, labs were supposed to ask, but it really questions about patients and illness were only asked. Thus, most of the candidates use the malpractice influencing the invigilators and other modes, for which invigilators cooperated the same to the candidates, favorable and free sources by the authority. Then there was entry of the unauthorized person. Unauthorized persons or unknown persons are also seen to be entered in the examination hall, and as they were found with the answer key with them and helped the preferred candidates, as the provision for correction is there, the candidates corrected the answers and subsequently ratified by the invigilators. Then lack of transparency. There was no transparency with much loopholes in the whole examination. Question papers as well as answer key was not published subsequently. The scorecard was also not published. There was no CCTV coverage to identify malpractices, etc., which clearly means that there was some sort of malpractice involved. Then no seal cover for question paper. There was no seal cover for the question papers. Only Xerox papers were given distributed as question papers as well as answer sheet. Thus, it is clear indication that question paper got out prior to the examination. Thus, the preferred candidates who were having favor got a chance to manipulate the examination. Then no sitting plan. There was no sitting plan for the candidates roll number wise. The preferred candidates were allowed to sit as per their convenience and taken the help from the neighboring candidates and got the help from the institution group. No ban to use mobile phone. Mobile phone was not debarred inside the hall. Thus, few candidates did sitting using mobile phone. 2. There was no mention in the call letter also. Hallucination about unfair means. Under the above circumstances, all the petitioners were all shocked and apparently raised to their mind that no fair means is being adopted, which is not expected in national level examination. The petitioners have never observed and adopted such means, which is against the principle. Then, lordship. Then, A. Non-inclusion of name in the skill test. Petitioners were stunned when they did not find their name in the list of qualified for skill test, candidate for skill test, and they were debarred from appearing in paid skill test. If all fair means would have been adopted, then the petitioners were sure that they could have established their competence. There is no doubt that the petitioners' answer sheet was manipulated to deprive them to create opportunity to the preferred candidates. This is really possible as no serial number was there in the answer sheet and Xerox papers only used. The petitioners believe that they could have able to score good marks as they have answered more than 25 correct answers. Non-maintenance of ratio for qualifying in trademark. Petitioners were seen that skill test trade test was for namesake only. No ratio was maintained, whereas the post is field one. No cutoff mark was earmarked for qualifying to written examination. And no proportional ratio has maintained for passing to the next level. From written exam to trade test, that is against 10 number of general category, was only 12 were allowed to sit for skill test. Last, there has to be double the number, madam. For 10, at least minimum 20 has to be selected. Only 12 persons were allowed to sit for skill test, by which a portion of deserving candidates have been deprived to sit for the skill test. Non-maintenance of reservation roster. For ST candidates, also no ratio was maintained in the written examination against 3 vacancies. Only 3 candidates were declared as qualified for trade test, whereas only 4 candidates appear for examination. Different modes for different posts. Just come to notice of the petitioners that in the recruitment process of all examination, different strategies have been adopted. Example, in the case of written exam for the post of LDC, after completion of written exam, all candidates are allowed to for skill test, even though for the particular post written examination almost important. Against 4 number of vacancy position, approximately 40 numbers of candidates in the written exam, all candidates are allowed to sit for skill test. Whereas in case of the petition, only limited candidates are allowed to trade for trade test. So here they have admitted, my lord, for LDC, my lord, the result was not declared instantaneously as in case of us. The immediate criticism to the complaint, as the whole recruitment process was full for anomalies and corruption involved to that, appointments order have been issued immediately after receipt of the written complaint about the anomalies from the candidates like the petitioner. The petitioners have sent their written complaint dated 25/8/19 at 1:45 p.m. of 26/8/19 and appointment order issued at 4 p.m. on 26/8/19. The appointment orders have been sent to mail itself and candidates were called over phone itself and instructed to join immediately so as to defend the management side. If appointment order is issued, appointment can also take shelter for law so that the management is stable. The lordship is aware of at least 15 days time is granted, my lord, after issuance of the appointment letter. They are in the instant case, they were directed to join immediately. Patient care is no great dilemma. If those candidates private as well get job in such a reputed institution or position, the patient care is a great dilemma. Having noticed about the anomalies as aforesaid, the petitioner immediately raised alarm and informed the investigator about the same. The petitioners during the period examination raised objection to the invigilator, but the authorities failed to give it response and did not give it a response to the protest of the candidates who have objected against the anomalies. Immediately after the written test was held, the authorities declared the result and conducted the skill test. It is stated here in that 24/8 being 4th Saturday, nothing could be done, and on that day, and only on 26/8, the petitioners have written to the Vigilance Officer, Tata Memorial Center, Mumbai, and reported the malpractice the examination held on 23/8 for the post of trade. Lordship would have also annexed the protest letters, Lordship, at page 29, my lord, of the writ petition. We have sent it via email, my lord, on 25/8/2009. With reference to the subject cited above, I am a candidate for the post of trade helper by roll number of so and so. In connection with the recruitment process, I would like to bring the following few malpractice and anomalies to your notice. By BPCI TMC so and so 15 July 19, I have been asked to appear for the written test at 23/19 and 9:30 AM on academic hub so and so. The process of recruitment was with full malpractice, not in proper way. This is quite so and so for me, following are some examples. Lordship, those whatever I've stated in my repetition, all those grounds are stated in the protest. Then, your Lordship, I filed my repetition, Honorable Court protected, given the interim order for stay the operation of the select list. But, your Lordship, in violation of that, they have accepted the private respondent, and as on date, they have protected the private respondents. They have not entered appearance as on date. Instead of coming to know about pendency of the writ petition.
Any statement, Mr. Dotto, how this person's done? What was the cutoff mark?
Yes, these are there, my lord. We have filed our affidavit.
You have stated in your affidavit that
Yes.
you have, a decision was taken by the selection committee with approval from the director.
Well.
That is fine. But what was the cutoff mark and how,
Yes,
what was the mark this person of?
my lord, if your lordship look at our affidavit,
Huh.
we have given very categorically all this reply. Lordship may kindly see at page 5, paragraph 11,
Page
page 5 of our affidavit,
5,
paragraph 11.
5, 11.
That in regard to paragraph 9A of the writ petition, your deponent states that there are no written norms which states that it is necessary to use OMR sheets for the examination. The pattern of the examination depends on the pattern which is set by the
No, that
paper
we have seen. We want that this was the that you come to paragraph page 7, subpara 3.
page 7, my lord.
Yes.
Statement made in paragraph 9K of the writ petition, the deponent states that based on the marks obtained by the candidates in the written examination, they are called for skill test. Cutoff marks of the written examination was decided by the committee with the concurrence of
What
the
was the
director.
cutoff mark and how this person performed? That
Yes.
we want to know.
The cutoff mark was the committee, they have the authority.
No,
My lord, I
no,
take your
that we
lordship
know,
to
that you have said. We have
Yes.
no quarrel on that. We have no quarrel on the power of the selection
Selection
committee
committee.
to have a cutoff mark
Yes.
even after selection.
Right.
That is not an issue. That power we don't have an issue.
Right.
But is it not necessary to say that this was the cutoff mark and this person obtained this mark?
Yes, yes. My lord, I am taking to your lordship to that.
That much we want.
Yes. Your lordship, kindly see the result. Your lordship will find 17
Result
and-
sheet is there.
Yes. 17, 18, they are the petitioner and the marks obtained by them.
Lordship, I am not aware of. It's not.
It's a record that we can verify. Who are this petitioner?
Dodumoni,
Forest.
Dodumoni and Forest.
Forest.
No, go through the record. This
So I
is the
can
record.
have a copy to her.
Huh?
This copy I
I'm
can.
not
start with.
aware of
No, go through it. This is your number.
when the
No, it's a
Yes.
writ of certiorari. We will certify the record, whether it is correct. That's why we asked the specific question. Because their affidavit is silent. They said we have had a cutoff mark, you have not scored. We want to specifically ascertain that statement from the record. So that's why I asked for it.
Yeah.
If it would not been here, I would have adjourned this matter and asked him to produce the record. He is with the record. We will give you a chance to go into the record. No case.
so I'm submitting
Hmm.
because there's manipulation, my lord.
They have specifically denied.
They will, my lord, in order to protect
How
the
can we how can we decide that? In a writ court, tell us. And first of all, in other aspect, this Bibura Cancer Institute belongs to whom?
My lord,
Tata
it is,
Memorial.
it's by the government of India now, Atomic Energy. They have
Government of-
taken it under the administrative control of Tata Memorial.
Tata Memorial Hospital belongs to whom?
Belongs to Tata Group.
Now this is a collaboration between
This is my
Tata
lord,
and State of Assam
Administrative control is up with them.
with
Assam
them.
is not there.
This is
Assam-
part of the atomic
Government of India is the Atomic Energy.
There is a collaboration between Government of India Atomic Energy and the Tata Memorial.
My,
So therefore it.
the 226, my lord, I don't have any question on it.
Okay.
It is maintained.
Just it was my because I was not aware of this
No, earlier
Trucks.
that point was there.
Ah.
But after taking over by the
union.
Government of India,
India.
that goes.
with the signature of the investigators are there.
Everything is there. 1, 2,
And
3.
there was no direction from this honorable court to produce the record, my lord. On their own, they have come.
That is important. That is very good.
No, it's good, my
We
lord.
appreciate.
Hello.
We appreciate that instead of adjournment, they are ready with the
Yes, my
record.
lord.
We appreciate it.
Question of transparency.
Yes.
Question of transparency.
1, 2, 3, 4, 5.
My lord.
5 persons. Member selection committee, member selection committee, member selection committee, all member selection.
Lordship, for ends of justice, let them give a copy to me.
Yes,
I'll
yes,
go
I'll-
to it. Let the matter be kept as part of my lord. In the coming week, maybe. Any take up.
Want to be in ventilation for one more day? Huh?
For 1 week, maybe.
Heard MSB Bhuya, learned senior counsel, assisted by B. Bora. Also heard Mr. S. Datta, learned senior counsel, assisted by Musahari. S. Musahari. S. Musahari. All S. S.
From B to B.
B. S. Musahari, learned counsel for the response. Since we have started, let us do some, we'll
Yes.
just record the facts.
Then there.
That will help us. That will help us on the next day, since we have already gone. The petitioners who claims to be working as working at the Bhubaneswar Borua Cancer Institute, within bracket, for short, the institute, bracket closed, as ward boy, participated in a selection process pursuant to an advertisement dated 8/9/2018 to 2021 for selection of trade helpers. Full stop. The grievance of the petitioner are that the petitioners that the ignoring, not ignoring, that there is a serious anomalies in the selection process, and accordingly, the petitioners had been deprived of their right of a fair selection process and their right to get an opportunity to be appointed pursuant to the impugned selection process. The basic grievances of the petitioners from the pleadings can be summarized as follows. Paragraph 9 or as follows will be A, B, C, D, E, F, G, H, I, J, K, L, M, N. Okay. The respondents have filed an affidavit and specifically denied such anomalies and allegations made in the writ petition at paragraph 11 of the affidavit in opposition, which can be summarized as follows. Okay. Paragraph 11 A, B, C. I will dictate this shortly. Okay. Later on. Full stop. A specific stand has been taken that the selection committee, in the selection process, the selection board has taken a conscious decision to fix a cutoff mark in the written examination, and on the basis of such cutoff mark, the candidates were called for the interview, and thereafter selections were made and the private respondents were appointed. Private respondents were sought to be appointed. Mr. S. Dr. Learned Senior Counsel has produced the record of performance of participating candidates in the written examination so far relating to the trade helper, and which goes to show that both the petitioner what is the petitioner number? Paresh Kolita, petition number 1.
Yes, Forest Kolita,
Ah.
Yadumani Kolita is petition number 1.
The petitioner number 1, Jodhumani Kolita, obtained 20 marks out of 100 marks in the written examination, and the petitioner number 2, Paresh Kolita, obtained 18 marks out of 100 marks. And what was the qualifying mark?
That is not there. They should have, my lord.
Full stop.
They should have mentioned, my lord, their cutoff mark. This was, I think,
Full stop. Full stop. out of total participant of 18 candidates under general category quality, under unreserved category, comma, 12 persons were called for skill test. However, however, anything on the decision of your selection committee's minutes that regarding cutoff?
My lord, that I'm just looking.
So, however, the record produced do not disclose the decision of the selection committee fixing any cutoff mark. Accordingly, Mr. S. Dr. Learned Senior Counsel submits that he may be allowed some time to produce the selection records pertaining to selection of trade helper at B. Borua Cancer Institute, including the minutes of the selection committee, the selection board meeting, wherein it was decided to have a cutoff mark, and also to show that the petitioners were below the aforesaid cutoff mark. Accordingly, matter stands adjourned and be listed on Mr. Datta
Any date convenient to you?
Mosumi, 28th of February.
Just
Then-
one.
Twenty-nine is Thursday.
Yes, all right.
If you're fit,
28th, okay,
if
28th.
you say 20
28
29 is Thursday.
29th. Too many methods are there. 28th will
20.
28th
Part one.
of March 2023. As this court has already, at the petition, learned senior counsel for the petitioner has argued the matter at substantial length, and this court has also gone through the records. This matter kept as part, at least be listed as part.
Doctor, liberty be given to advance my argument.
Yes, yes. This is part hard
Yes.
means you will have.
Yes.
This is preliminary.
File,
Okay, don't think that we have taken a.
file.
This is preliminary.
It is always open.
Always open. In this court, this is always open
No, no,
till
it's
last
always-
moment.
The lordship is so liberal.
Yes,
We are free to say everything.
If it is something, we'll change our, not a problem at all.
Yes.
We are not always correct. You enlighten us, we'll decide. You
Right.
rely on judgments, you rely on this.
My
This is
lord.
prima facie. Yes. Mr. Doctor, have the selection record so that we can see everything, your decision and their cutoff, what was the cutoff mark. They have scored, we have seen that, what was their code. But it is nowhere discernible that this is the cutoff mark, therefore they are out. For at least for their satisfaction, they are entitled for fairness, fair treatment.
My lord,
That
even, my lord,
Hmm.
your lordship kindly see in such circumstance, supposing there is no cut-off mark, while you are appearing in the interview written test, there is no demark.
no, that we
Knowing
no,
everything
no,
you have-
no, that is another aspect. We generally we test in the touchstone of Article
Yes,
14.
your lordship is very
Isn't
correct.
it?
Yes.
So if you have a decision, reasoned decision that okay, fine, we are taking this cutoff mark. Suppose because this is a right to the second stage.
Right.
It's not final. It's not final. It is right to the second stage. Suppose there is no decision to cut off. You say okay, fine, verbally let us have. How do you know that? Every state action must be informed by reason. That's all. Yes.
They will provide a copy of the mark.
Ah, say, okay.
Yes,
I, R. Gogoi. Mr. Nayab, a new trend we are looking at. We do not know whether it has been taken that these courts are lenient. Even in contempt, where there is some person enters appearance lawyer, persons are not there, nobody is appearing. No, no, not to, that's why I'm asking you.
I
No, no. See, okay, fine, you are here. Yesterday, same thing happened. In many cases, we may call that lawyers is not present, call the person. That is the easiest way to do that. But at least somebody should be sent that, okay, this is Mr. Gogoi is on legs. So that he's not, even by he can give a message to any of his colleagues that he's on legs. These are contempts. Don't take, you do that. Sometimes it happens to most probably health. We were not blaming, you are assisting properly to the courts, but contempt sometimes becomes difficult. Yes, Gogoi.
Sir, I before
Mm.
question number one,
Mm.
Commission Secretary. So, well, the communications are only up to 2021 in my file. Let this matter come on Tuesday, madam.
Now understand, nowadays there is an advantage. You have a link. You can click what order was passed on last occasion.
That blue column.
Yes. That's why we have given it to you.
Hmm.
Maybe from second half of this year, you will have everything, including the affidavit,
Well,
including the writ petition. So there is an order on last occasion. The same submissions from you. Nowadays, you cannot say that I have not gone through the file.
no, I have gone to the file.
But the same, you have received some instruction and praise that he may be granted 3 weeks time to file affidavit. So your officer, if is in a mood that whatever I wanted to required to do, I have done it. Forget about Mr. Gogoi. We'll record that he has received instruction to 2020. There is thereafter no connection. So let the person be.
What had happened basically, madam, in this
That we have seen last week. Everything we
this
recall.
case, madam, this Commissioner Secretary was not a party, madam.
Hmm.
That case.
Hmm.
Now, in a petition, in this contempt, madam, he's been made a party.
Maybe is it not permissible?
It's permissible, madam. So communications are 2021. Let me have some instruction if by 2 months if
Okay.
I get.
Not to.
Can I get new car?
That's why blue link.
It's not. Oh, 9. Oh, hello. This person is not there anymore.
Who is he?
Rakesh Kumar, Commissioner Secretary.
Rakesh Kumar.
Commissioner Secretary. Madam.
Now who will implement this order?
The secretaries have already party medals by secretary by his office, authority of his office, my lord. Secretary, deputy chief, chief engineer.
A small determination when he entered into the service. And on the basis of that, you will have to take a decision whether he will be entitled for pension or not. And this order was passed on 7/8/2019. Yes, madam. Are you having any link connection with your client? No. Will you be in a position to take?
Not a detailed comply the order. It is as per instruction of my.
When was the last instruction? 2019 or 18?
No, Lord. Last week.
Last week, then why you did not appear in the case when it was called on
Last time.
16/10, on 13/12?
Yes.
Huh? Because of pension, we have not dismissed it. Because it relates to a pensionary benefit. We cannot be responsible. Lawyers may be. Isn't it? Yes, Gogoi, help us. Who will bring the instruction? Upadhyay. We'll fix after 2 weeks. We'll fix after 3 weeks. Madam, give a copy to.
I'll hand over.
No. I don't know what about.
Okay. This contempt petition is filed alleging willful and deliberate violation of this court's order dated 7/8/2019 passed in WPC 4370/2017. Full stop. A dispute as regards petitioner's entry into service was raised in the writ petition and consequent claim of pensionary benefits. Full stop. This court, by the aforesaid order, directed the employer to verify whether the petitioner entered into service in the irrigation department and whether in the year 1984 and if it is ascertained that he was already in service in the year 1984, he be granted consequential pensionary benefits. Full stop. This matter is pending since the year 2019, and in the meantime, the alleged contemner has been transferred from the department. Full stop. In the aforesaid backdrop, this court has requested Mr. N. Upadhyay, Learned Standing Counsel for Irrigation Department, to assist this court and ascertain whether the verification as directed by this court has been made and the order in question has been complied with. Full stop. If not, the reason thereof.
In
Full
fact,
stop.
Lordship, just for now, 1, 3 and 4.
Hmm.
1 has been transferred, 3 and 4 has retired.
Okay. We will not go
No,
through.
Lord.
Okay. Except ultimately pension and contempt. So
No, no.
you can, I think you can do the needful
No, sir, I can-
after your name is shown in
No,
the
sir.
cause list and disorder.
Lordship, Lord. Lordship.
You can, na? This is better. Why
No,
should?
we-
Yes.
we can do it.
Last Okay. Yeah. Full stop. Release this matter after 3 weeks and on given date. 4th of March 2024. Registry to lease this matter reflecting name of Mr. N. Upadhyay in the cause list. Full stop. The learned counsel for the petitioner shall furnish 2 copies of the contempt petition to Mr. N. Upadhyay by Monday is a date by
19.
19th. Give a copy.
All right.
Please take one. Yes, Bhagavati.
Lordship, I am being instructed that this order has been complied with, Lordship, and he is also getting his
Current salary.
Lordship,
Pension.
pensionary benefits, Lordship, everything.
I have got, my Lord, a portion of the amount.
Lordship, I am
Not
told
the-
that everything was given, Lordship. Telephonic instruction, Lordship. Last 6 months, he have been getting, Lordship. This is
Retired.
exactly, that's my. This is of 2022,
Yes.
11/22. At that period, Lordship, for some reason, Lordship, there was some treasury rejected the bill, Lordship. Subsequently, that has been paid.
There is a dispute regarding some recovery. If they have done recovery, that cannot be a subject matter of the contract.
That is their internal matter. But respondent number 5 manipulated my date of birth because I did
Is
not
it a subject matter? Where is the order?
order maybe sent by the page 9 on order of the Honorable High Court. Operative portion may be seen by the page 12. Para 9. Or for 8, from 8 it may be read.
You have been paid 2,70,000 area bill 243,528. And an adjustment was made of 217,530.
Okay, some more letters that are the mail.
Anything
They have sent something by mail
to courts, ma'am?
to court. Lordship, now my junior have given it.
Yes, yes, give a copy. Are you in touch with your client, Mr. Mahmood? No.
About 1 month back, she said that I have got some amount, but not the full. And my Daniel Prince letter is November 20. So I think he has not got the full amount, which is entitled to him. That is, because 1 month earlier I had a talk with the part.
If there is a mistake in recalculation, that is not a part of it.
It is done intentionally by them. My date of birth was tempered. It is the finding of the court. But against respondent number 5 who did this, no action is taken. It is of course they are internal matter.
Mahmood, then we'll have to bring on record what you have received by filing an affidavit.
I pray that the better come after 1 week. I take that is
Okay. Mr. M. Bhagavati, Learned Counsel appearing for the respondents, has submitted that the order has in the meantime been complied with, full stop, and complied with the after full stop, after refixation as per direction of this court, payment has already been made, though there were some deductions.
Deduction because he was already getting it.
Deduction in terms of the court's order in question. Mr. Mahmood, on the other hand, submits that though his client has received certain amounts, but not in full. In that view of the matter, Mr. Mahmood should file an affidavit to that effect, bringing on record that in terms of the order, that the order dated so and so has not yet been complied.
Okay. Earlier what he said.
Let him file an affidavit. Possible? You are saying,
regarding
he's
the
saying
deduction law.
deduction and what is the amount? You must have a communication, treasury, you have received. So you say that this is the amount, this is.
the mind that yes, this is some amount.
So therefore, you are not saying that the order is complied with.
Not fully complete.
So therefore, you file an affidavit that I have received this and not this,
But I wanted.
or you are closing it.
No, after 1 week, let it come.
Ah,
I will take later instruction.
that's why we have shifted the burden to you.
All right, sir.
Material instructions also.
You have the instruction because you have the information. Now you have all instruction, whatever necessary. Okay.
No, actually.
Yes, yes. Next case.
What's up?
Yes. If so advised. No. Like that. Item. Yes. Yes.
Right.
Yes, that will go to later on. What is the grievance? Dismissal, termination, black mark, discharge on disability. Now, what was the punishment? Page? Where is Union of India? Page 17? Hmm? Okay. Annexer? Yes. Hmm. Okay. Hmm. Hmm. Then page 46. Hmm. Now what is wrong in this order? Yes, who is for the Union of India?
Lordship, SS Roy, he's out of this. I just called him. I think he was under the impression that this matter would be adjourned today. I just called him and it was supposed to be adjourned.
Will not compel him, will not go proceed with Saturday. It is submitted that Mr. S.S. Roy. What is the stand of the union? What you are relying on which rule? What says rule 40 says? What it says no qualifying service? We'll hear it. It is submitted that Mr. S.S. Roy, Mr. CGST is having some personal difficulty today to argue this matter. Accordingly, prayer for adjournment is made on his behalf. Prayer stands allowed. I list it on divided 18th of March. We'll decide on that. Rule 40. Please.
Instruction not received.
Huh?
Now I talked with them. The 2 weeks time is given. Within 2 weeks, we will file the affidavit. Instruction is not received.
About 2.5 years back, he gave to receive his pension. But he completed around 26 years of service. Lordship, the regular post.
When can you have it?
And 2 weeks time is given. We
You are for BTC,
no, my lord.
PWD.
PWD.
On the prayer of the learned council for the standing council for the PWD
M.
department.
Das.
Huh? And the
M. Das.
M. Das matter stands adjourned and be listed On-
He received.
on
2 weeks time is given.
on after 2 weeks divided. Seventh of March.
PWD.
This court expect that in the meantime, the petitioner, the respondent, PWD shall file their affidavit in as much as the claim relates to pension and pensionary.
So they have taken part of-
We have seen that.
My-
Yes, Mr. Bora. What's in that case? Okay. Do you record? Should we record your name? Okay, as Bora for BTC, and you are D Rava for Accountant General A. Yes.
Promote.
In this matter, we'll be filing an affidavit. 3 weeks time may be given.
What is the issue here?
Promotion of
Okay, who's irrigation?
Lordship, we have filed an affidavit saying thereby that we have transferred all documents to the Secretariat Department, Lordship.
Okay,
Who will the authorities inform?
okay, Mr. A. Fukan, come on. An affidavit has already been filed by the irrigation department. Full stop. Mr. A. Fukan, learned standing counsel for
Respond number 1.
respondent number 1. Praise for and is granted 2 weeks time to file affidavit.
Well.
Please record.
Deeply obliged.
Okay. What was the prayer?
Lordship, page number 12.
The
Setting
none appears for the petitioner on call. The present writ petition is filed assailing a minutes of meeting of SLC dated 23/12/2019. So far, the petitioner is concerned, whereby the case of the petitioner was negated by the respondents. The basic ground of challenge is that in spite of this court's order dated 27/5/2019, passed in the earlier writ proceeding filed by the petitioner being WPC number 3363/2019, the respondents are not taking any action. Full stop. While this court, under its order dated 2/2/2023, observed that in view of the earlier direction, the appropriate action would be a contempt petition, not a writ petition. Accordingly, matter was adjourned on the prayer of the learned counsel for the petitioner on 2/2/2023. Full stop. When the matter is listed today, Mr. C.S. Hazarika, learned government counsel, has submitted that in its subsequent meeting held on 2/3/2023, the name of the petitioner has been recommended for appointment on compassionate ground by the SLC. In that view, a copy of the such minutes dated 2/3/2023 is also produced before this court. In view of the aforesaid, nothing survives in the writ petition to be adjudicated. Accordingly, same stands closed. A copy of the minutes is kept on record and marked as document Exa লিখে দিব ভালকে document X. Here and thus M thus appears for PW. উপর দিকে। কোনটাতে? Yes,
On last petition. Dear petition also was directed to.
Nayak was here only. He has done something. Okay, Mr. P. Nayak, learned counsel for the petitioner, submits that. Yes, how much time? Nayak, PWT. If you want to make a submission, you can make it. Not necessarily Nayak is required. What is your instruction? Yes, Mr. Nayak, you are supposed to file an affidavit.
Lordship.
What is this? File an affidavit.
Lordship, that will be required.
Okay.
In earlier occasions also.
No, that's true. But do you want to proceed without the affidavit today?
No, no.
Oh, then, Mr. P. Nayak, Learned Standing Counsel for PNRD Department submits that, not PNRD.
Engagement. Lordship, in so far as PNRD on is concerned, Lordship, I appear only in the issues relating to recruitment. Other issues department.
Okay, okay,
I'm appearing for finance.
okay. Or a division bench judgment, you are seeking benefit.
No, there is a separate judgment for us, which says that we are entitled for provincialization under the 1999 Act. Thereafter, there was another judgment. Now, what they have done, they have.
This will require some deliberation.
Yes.
Because so far, I recollect that judgment was in a given facts of a specific regularization and subsequent another regularization.
Yes.
We do not know about the facts of this case. It will depend upon the fact. Mr. P. Nayak, Learned Standing Counsel for the Finance Department, prays for and is granted 2 weeks time to file affidavit.
Make it few.
3 weeks.
We have
time.
to.
List accordingly. Make a mention, we'll allow it. Okay? 3 weeks.